Hi, I'm Lois Beasley-Carlisle with some more advice on filing bankruptcy. When you go in to see your attorney is going to do several things for you. They're going to evaluate the assets. They may ask you to run a NADA evaluation. They may do that for you. They're going to do a lawsuit search. They're going to do a lien search. Or they may tell you you need to run down to the courthouse and check and see if you have any liens on you. They may ask you to pull all kinds of financial paperwork and bring contracts so that they can read them and evaluate them for you. If you're married, you'll have to give them information about your spouse. If you're living with your spouse, their income. The attorney is going to have to know what you and your spouse have made for the last 6 months, and they're going to have to produce your tax returns, and they're going to have to produce your last 2 months' pay stubs or bank statements showing your pay stubs. They're going to have to produce a tax card for the court. Some counties you can pull that off of the internet. Some attorneys will have you bring that in. They're going to again have to file a motion of value for the vehicles, maybe an AP to strip a second mortgage, which the AP again is the lawsuit. If you qualify in a 13 to do that, you're going to have to do certain things during the life of a 13. And one is you're going to have to keep your attorney advised of your address changes. I keep up with a lot of my clients on Facebook because addresses change over 5 years. Telephone numbers change. Jobs change. And if attorney can't get a hold of you and there's problems arise with your case, which they can at any time during the 5 years, then your case can get dismissed. Orders can be entered against you if your attorney can't get a hold of you. So always let your attorney know where you are. Your car could be repossessed, your house could be foreclosed, your wages could be garnished. Lawsuits could resume against you without your knowledge. Judgments could be entered against you without your knowledge if you disappear and don't let your attorney know where you are. You have to provide accurate creditor addresses to your attorney. They don't know who you got into debt with. If you don't give the accurate creditor addresses, those creditors might keep on doing stuff to you while you're in bankruptcy because they don't know about the bankruptcy. Sometimes creditors do things on purpose and you can file an AP against them for doing something wrong. Sometimes creditors do something wrong after you go Chapter 7 and get your discharge. The attorney, you can go back to them and they can file a lawsuit against them for a discharge violation. Sometimes they can file a stay violation AP against them while you're in bankruptcy. Creditors don't always do things wrong. Most of them will obey the bankruptcy laws, but every once in a while you get one that thinks they're above the law. Once you bankrupt and discharge a debt, it's discharged. If somebody calls you several years later trying to get that money out of you, you need to try to get a hold of your attorney before you pay anybody a penny. Maybe that creditor didn't know. Maybe the debt was sold. Maybe the company that bought the debt didn't know. And it may be just as simple as getting them a piece of paper from the bankruptcy court showing them that the debt they bought was bankrupted on. It could have changed hands in the meantime. The bankruptcy court's not going to notify somebody that the attorney doesn't have a good address for. So if you don't list a debt properly or you don't list a debt, it may not be bankrupted on. And if you think you listed it and you didn't, well, you may be surprised at the end to still owe a bill. This is your personal responsibility to get those bills to the attorney. We run credit reports, we do lawsuit checks, but that doesn't mean we're going to know all the creditors that you've done business with. If you get your attorney fax numbers for your creditors, the attorneys can fax them notice of the bankruptcy immediately and make them stop contacting you immediately. If not, they're all going to get mail within about 3 days. You need to get your attorney the date the debt was incurred, the creditor's name, address, account number, and the balance of the debt, and the payment amount on the debt so they can properly evaluate the type of bankruptcy you need to file. You'll need to bring in a list of personal property in your home and the cost of replacing those items in their present condition. In the alternative, you can get an appraiser to appraise all the stuff in your home and take that to the attorney. Generally with a Chapter 7, if it's a straightforward Chapter 7, there's going to be one meeting, and in 3 to 6 months, you'll get a discharge. In a Chapter 13, there can be multiple court dates. Now, when you go Chapter 7, you fill out a piece of paper called a Statement of Intentions that tells the creditor whether you want to keep their debt or let it go. if you want to keep a debt and keep on paying it, you need to try to get your creditor to send you a reaffirmation agreement. Some creditors will send reaffirmation agreements, some just let you keep paying it and you quit paying it and they go pick up the object, the car, foreclose on the house or whatever. If you don't reaffirm on your house, then you're not going to be eligible for a loan modification later on. Now, we don't chase down creditors to do reaffirmations. You can come in our office and we'll call the creditors with you. We'll let you get them on the phone, and then we just tell people wait and see if they send us a reaffirmation agreement in 30 days. If we don't have one, you need to come in if you want to keep that debt and you want to reaffirm it. Some creditors will email them, fax them. Some creditors will mail them. You only have 45 days from the date of the filing of the bankruptcy to reaffirm those debts, or you need to get with your attorney and ask them to file a motion to extend the time to file the reaffirmation agreements. Again, arrange a meeting with the attorney. Don't just leave a phone call. Leave a piece of paper at the lawyer's office, because that's not going to get the debt reaffirmed for you. Some creditors will let us fax reaffirmation agreements that are signed in, and then they will sign them on their end. Some creditors want the original signatures. Again, if you want to reaffirm something, be responsible, meet with the attorney, make sure that you have reaffirmed it. Go meet with the attorney about 30 days after you file the bankruptcy. Now, once you've sent it, what we do is we have clients, if it's got to be mailed, we have clients mail it to the creditor, certified mail or something, so they can have a tracking number. Then you need to follow up with the attorney and make sure the creditor actually filed it with the court. Now, you may have other lawsuits going on during the time that you're in the bankruptcy. Some of them can keep on going. Some of them you have to ask court permission to keep on going. And some of them stop. Sometimes, and you just have to talk to your attorney about whether you want your attorney to represent you on those lawsuits, like child support collection lawsuits. Those are the more likely kind that's going to keep on going. Now, also, if you have liens on you, it's your responsibility to make an appointment with the attorney to get that lien off of you. The attorney may not know the lien's on there if you don't bring him a copy of the lien. How do you find the lien? You go to the courthouse, to the probate court, and you look. You get the clerk to help you look. You say, I want to know if there's any liens on me, and if it is, you need to take the attorney a certified copy of the liens on you. And then the attorney will file a motion to avoid the liens. Sometimes you don't need to file the liens if you have no assets. Again, that's going to be an individual decision. You'll have to talk to your attorney about it and see. Also, when you have other lawsuits, you might need to file a suggestion of bankruptcy on those other lawsuits to stop them. You need to bring the lawsuit paperwork to the attorney so they know where the lawsuit is. We can pull up and look for lawsuits, but if you have a lawsuit against you in New York or another state, we're not going to find it. And sometimes creditors misspell your names. We may not find it. When you're in debtor's court, you do have a responsibility to keep your child support and alimony current. At the end of the 13, you're going to have to go in the attorney's office and you're going to have to sign a form that says you have paid all your child support current and all your alimony current if you owe it. If you don't keep it paid current, you're not going to get a discharge, and your bankruptcy will get dismissed. You also have to keep your house payments current if you're staying in your house, or that creditor can file something called a motion for relief from stay. Now, sometimes you get 2 or 3 chances on those motions for relief from stay. Sometimes you don't. It depends on the equity in your house, the judge's perspective, how many payments you made, how far into the bankruptcy you go. If you're underwater and don't have the money to pay it, and that's why you're not paying it, you may not get to keep your house and you may have to move. The automatic stay is an interesting creature. If you've had a bankruptcy dismissed within 1 year prior to filing this bankruptcy, you're only going to have stay relief for 30 days. And if you need to stay longer, you need to have your attorney file a motion for extra stay. If you've had 2 bankruptcies dismissed within a year prior to filing, you're going to have to file a motion to impose a stay. You're not going to have any stay, and the creditors can keep on foreclosing or whatever. And filing a bankruptcy a day before foreclosure may not stop the foreclosure at that point. It may not stop a repossession. Also, when you hire your attorney to do a bankruptcy, it didn't mean you hired your attorney to represent you in those other lawsuits other than maybe getting them stopped. It doesn't mean you hired your attorney to go to divorce court with you. It doesn't mean that you hired your attorney to do a will, handle a probate estate if somebody that's helping you pay for it dies while you're in bankruptcy. All those type of things are separate court proceedings and require separate contracts and separate payment arrangements with the attorney. The bottom line is you need to make sure you cooperate fully with your attorney. You always stay in contact with your attorney. You go get immediately whatever paperwork the attorney directs you to get. You take your tax returns to your attorney every year. You don't pay creditors outside the filing of the bankruptcy without asking your attorney. Most mortgage payments are made outside the bankruptcy. Every once in a while, there'll be a reason that you and the attorney will agree to put the mortgage payment in the bankruptcy. Again, so I'm going to hire an attorney to file bankruptcy. What is the attorney going to do? They're going to analyze your financial situation. They're going to render advice and assistance to you and prepare documents for the court. They're going to prepare a 7 or 13 petition, schedule, statement of financial affairs, and other documents required by the court. They're going to represent you at the meeting of creditors and the confirmation hearings. They're going to help you review claims, file claims, object to claims if necessary, file amendments, motions, adversary proceeding complaints, lawsuits, answers to other complaints, and other proceedings that arise in a Chapter 13, of which there are many, many proceedings that can occur. Now, before you file a 13 or a 7, you have to take a class. There's several agencies that give these classes. As soon as you file the bankruptcy, you have to take a second class. You don't have to take a test. You're not going to pass or fail them. You just simply have to take them, and you have to bring the certificate to the attorney and sign forms that says you took them. And you have to you're not going to get a discharge in either type of bankruptcy, 7 or 13, if you don't take those forms for those classes to the attorneys so that they can file the appropriate papers in court. Again, this is Lois Beasley-Carlisle, and more bankruptcy advice. And the standard disclaimer is no representation is made that the quality of legal service is better than the advice that any other attorney gives you. Thanks. Take care.